Well, welcome to Judiciary Non-Civil.
Thank
We
you.
couldn't think of a better deliberative body to have you come and present your first bill in, so welcome.
Thank you, Mr. Chairman. I probably couldn't have picked a worse committee to introduce my first bill. So, I meant by scary. It's set in front of a bunch of lawyers. So, yeah. All right. So, obviously, I'm new, so I'd go ahead and.
Representative, what I might suggest is tell us your House bill number and the LC number that you are working off of.
So House Bill 197, LC 480780, and it's a bill on fentanyl. It's a fentanyl bill.
Okay. If you want to, just walk us through each section of the bill.
All right. Can I kind of make a background of why I introduced the bill?
Sure.
So I'm a retired firefighter, EMT, and throughout my career, I've run countless numbers of overdoses on fentanyl. I've literally ran a call 3 times, the same person, 3 days in a row. I mean, while I was on shift. We would go out, they were essentially dead from an overdose. We'd get them back, and then we'd go back out to the same house on the next shift. So obviously we're in a war with fentanyl. It's pouring across our border, and I think that we really need to do something drastic measures to get it stopped. If anybody doesn't know, it's 50 times more potent than heroin, and 100 times more potent than morphine. So think about that. So 50 times more potent than heroin. That's insane to think about. So obviously what's happening is the people that are distributing it are adding fentanyl to increase the high, and it's not something that you can just take and get hooked on and go to rehab. It's something you take and you die. It's not just you can't recover from it because it's just so problematic in America right now. And just some background, in 2021, 41,587 people overdosed on fentanyl. And then in Georgia, DPH did a study from 10 years old to 19-year-old. It's increased 800% on overdose. 10-year-olds. So it's super scary that the kids, 27% of kids in Georgia do not know that you can take it one time and you're going to die, which that's obviously a marketing problem we have, which we can, address on a different level. So the bill essentially is, so fentanyl is legal in hospitals, and they use it, to obviously put you to sleep. So it's a Schedule II drug. But what we're going to do is that we're going to take it out and create a new subsection for fentanyl. The first part of the bill enhances the penalties for anybody selling. Now, this is a distribution bill. It's not for users. It's people that's actually selling fentanyl. So they're going to, anytime you're selling within 1,000 feet of a treatment facility, it'll increase the penalties on that part, so we can kind of help alleviate people trying to sell to people that are in a rehab. So I named the bill Wesley's Bill. Senator Clint Dixon's cousin, he died of an overdose, and that's why I named it that, overdose of fentanyl. So in the felony murder, so on the new part, since we created a subsection, a person committing an offense of murder in a commission of violation of subsection, he or she can cause death of another human being, irrespective of malice or intent, by manufacturing or distributing any controlled substance that contains Schedule II controlled substance fentanyl as provided. Where the accused is charged with offense of murder based upon the distribution of controlled substance, lack of knowledge that controlled substance contained fentanyl shall not be used as a defense. So essentially, if I if I'm a distributor and I have, obviously I'm distributing fentanyl 4 ounces or more, you're just, you're selling drugs, and I sell to someone and they die, you're going to possibly be charged with homicide. So, and you can't say, well, I didn't realize it had fentanyl, because everybody's going to say that, I didn't realize it had fentanyl in it. It was laced with fentanyl. So that's one of the things we're changing. And then obviously we're going to increase the penalties from 5 to 7 years on 4 to 14 ounces, and then increase the fine to $50,000. 14 grams or more up to 28 grams is going to be increased to 20 years or $100,000 fine. And then 28 grams or more is going to be 25 years or $250,000 fine. And then we added that any sentence imposed shall not be suspended, probated, deferred, or withheld, and the charge shall not be reduced lesser offense merged with the other offenses are served concurrently with any other offense. So essentially, we are cracking down on fentanyl to stop our kids from dying from it and our population from dying from it. And so that's pretty much the gist of the bill.
Okay. All right. I'm going to stop my little watch right here for you. You've got about 4 minutes left. If you had anybody here to testify on your behalf.
Well, I didn't get anybody to come in. I know I talked to PAC. They were definitely for increasing the minimums. If they would like to come and speak. I don't know if Peter's here or not.
We'll get them shortly.
But no, I don't really I didn't bring anybody in else to.
Okay. We have some questions from members of the committee. Who's number 14? All right. Vice Chairman Reeves. And remember, this is questions for members of the committee, or questions for the bill author.
Great job on your first presentation.
Thank you.
Atlanta's blessed to be a transportation hub for good things, but I like these penalties you have for distribution. Is Atlanta a hub of distribution presently for fentanyl and opioids, and is this bill something that you're doing some good on that about?
Well, Georgia's got one of the, Florida has already increased their minimums to essentially similar to this. South Carolina is in the process. And so I think that we do want Georgia to be the lowest on minimums. And obviously this is a thoroughfare from Florida. A lot of the fentanyl's pouring in over the border. So I hadn't done any research on how they bring it through. I'm sure that a lot of it comes in through Miami and places like that. But 85 is definitely a thoroughfare.
My wife spoke at a funeral of a classmate from Florida, and the authorities in that fatality from opioid or fentanyl said it more than likely came from Atlanta. Most of it does. So, thank you for doing something to cut off the fentanyl distribution out of Atlanta and Georgia.
Thank you.
Who's got number 6 over there? Representative Kendrick.
Thank you, Mr. Chair. I might have missed this. Could you tell us what the current law is of a controlled substance that's laced with fentanyl, what the charge is?
Well, fentanyl is actually currently a Section 2, so a Schedule 2, excuse me. So it's 5 years now, and we're increasing it to 7, and then I'll have to get back with you on the other. It's 5, and we're increasing it to 7, and I don't have the old bill. I apologize.
Can I ask a clarifying question? I guess I'm trying to see if is the charge murder right now if somebody has a controlled substance and it's laced with fentanyl, or what is it right now as the law stands right now? What are they charged with?
Right now, the DAs they can add homicide to it, and obviously it wouldn't be you couldn't, it's changing it so you couldn't say that you can say you didn't know it had fentanyl in
Gotcha.
it. But this is changing that to say that even though you sold it and it has fentanyl, your lack of knowledge is not a defense.
Thank you.
Who's got number 11? Sue, Representative Mahoney.
Thank you, Mr. Chair. Good job, Representative McCollum. I know you and just to be very transparent, I know you and I talked about this bill a lot. And just looking at the line 1415, it references Code Section 1613-30, and it says in the commission of a violation of subsection B and C. And if you look at that subsection B, it does reference manufacture, deliver, distribute, dispense, administer, but also sell or possess. And then the line 1617 goes on to say, when in the commission, let's see, in the violation of those sections, he or she causes the death of a human being by manufacturing. So I think there may be possibly a clarification there, because I know that you had specified that you want this to be a distribution, not possession or selling.
Well, and let me make it clear. I want to make sure that we have in Georgia have a amnesty bill, amnesty law right now. So I want to make sure that people don't not call because if you're at a house and your buddy overdoses, they can call and have amnesty that they won't, unless obviously they are distributors and have a whole bedroom full. They'll have amnesty. But yeah, I just want to make sure that this is for distribution, 4 ounces or more. So how we clarify that, we just want to make sure that it's actually a distributor, not somebody just selling somebody one joint laced with fentanyl or one pill laced with fentanyl.
And so, and can I ask another question, Mr. Chair? So I think we have to be very clear on that, since it does references a section where it does reference seller possession, going down to that line 19, 20, 21, that subsection 2, where it then states where if you're charged with offensive murder based on the distribution of controlled substance, and I'm assuming it's referencing one, that lack of knowledge is not a defense. And that in itself, I'm uncomfortable with it. And I know I've expressed that. And I'm sure there may be people that are going to testify to that. I personally do not have the answer right now as far as how we can change it. But I just, in general, I just feel uncomfortable having just a blanket law that says you have no intent, has nothing to do with being charged with murder. And so, and if you want to say a little bit about that part.
Well, I mean, I just feel like the drastic times, drastic measures, and the way fentanyl is, it's not forgiving. We can't, it's not like I said earlier. It's not one of those things that we can. You just try, you get hooked on or anything like that. You use it one time and you die. So cracking down and really iron-fisted, I guess, for the lack of a better word, is going to be something we're going to have to do. Obviously, if somebody's selling it, everybody's going to say, well, I didn't know it was laced with fentanyl, even though you got a whole trunk load. And these distributors, when they buy a product and they've spent their money on it, do you think that if they find out it has fentanyl in it, they're going to throw that away? No, they're going to continue selling it. So, I mean, it's a product they paid money for, or somebody fronted them. So if you think about distributors and you got a cartel that said, hey, here's a bag of cocaine, you sell it, When you get it sold, you pay me for it. Well, if it's laced with fentanyl, they've already took the product. They're going to continue selling it to make their money to pay them, or they're going to be dead themselves. So it's not something that they find out that fentanyl's in it and they throw it away. They're going to continue selling it. So that's one thing that's super scary, because, we're talking about drug dealers here. So, I mean, it's not like, it's packaged and it's got a label on it from the FDA.
And I think the intent of the bill, and definitely I think we have to do something about fentanyl. And again, I don't have the exact answer to where and how we should reward it, but it is up to, in any criminal case, it's up to a prosecutor, and it's their burden to prove beyond a reasonable doubt any type of crime against a defendant. And so taking away a defense, I'm just, as a lawyer in general, I think that makes me uncomfortable. I do think that your reasoning is very honorable and understandable, and I think that's maybe a conversation we need to continue to have.
May I say something, Chairman? Well, and then one other thing is, this tool, if you think about a DA and he says he has somebody that did this, and if this was in place, he could use that as a tool to flip somebody to get somebody higher, obviously. But without this, that tool of homicide, if you can't prove it with that person, he's not going to be able to flip them to get a bigger fish per se. So that's one thing with this tool that possibly could be used to actually get up the food chain. So.
Thank you.
Who's number 13? Charlize. Representative Burton.
Thank you very much for this bill. I totally agree that we have a fentanyl issue. Number one, the only way we're going to stop it is take care of the border and catch it there. However, if someone chooses to take a drug anyway, I mean, it's all intent to get high. I would say that would be a correct, right?
Yes.
And of course, when you're starting to get high, you don't know whether it's got fentanyl in it anyway, correct?
Right.
So I want to be clear. So if I start distributing around this room and you die because you've taken a drug that I've given to you, so everybody in the room is going to be charged, or am I going to be charged, or who exactly? Or is it just the person who's distributing it to me and then I'm going to give it to you, sell it? So could you highlight that, please?
Well, obviously we're going after distributors, so the 4 ounces comes into play, 4 ounces or more. I mean, like a gram, 4 grams, thank you. So the 4 grams comes into play, so you're a distributor, and that's who we're going after. Back to what I said about the amnesty, if you're in a room with a bunch of buddies and you give them all joints laced with fentanyl and they die, you have amnesty because you don't have 4 grams or more. So I don't know exactly, is that kind of what you're speaking of? Or are you saying that, I mean, if you've got enough in this room, you're going to have 4 grams to give everybody, it in here. So you are a distributor, right?
So if someone chooses to take the drug on their own free will, personal responsibility, but yet you want to charge somebody else, which I understand, you have given a bad drug to someone, but if everyone is in this room, how is everybody going to know who actually started the whole giveaway?
Well, I mean, I'm not saying drug dealers are the smartest, but I mean, when you obviously take a drug, there's a chance it has fentanyl in it. So, but I guess if you're a drug addict, that maybe may or may not matter. But if you're distributing and you've sold it to one person down the street and they probably died and you continue to sell it, I mean, where does it stop if we don't put some kind of roadblock? I mean, like I said, they're not going to stop selling it just because they know that it has fentanyl in it, are they?
Probably not. I
Right.
mean, we're never going to cure all the evils of this world. And just a follow-up question, shouldn't it not be the Justice Department that makes all the decisions of how long someone should be in prison or get a sentence? I want to know. Well,
we have minimums in place. So, I mean, so we're increasing the minimums, increasing the fines, and then making it so they can't get out on probation in a year. So if you get caught with fentanyl, and you're going to serve that full 7 years or whatever it is. So, yeah, I mean, they have if they want to give them more, but they can't give them less, because obviously now, and I'm not saying about all DAs, a lot of the DAs, if they might not want to charge but a year. So, I mean, if you leave it up to discretion of them.
Thank you.
Who's number 14 over there? Yasmin, or Representative Neal?
Yeah. Thank you, Mr. Chairman, and thank you for the bill. I understand what you're trying to do overall. I just don't know if this is the way to get there. But I want to speak to a few points. One, to Representative Hong's point, which is one I really don't think we should ignore. So I know your intent is distribution, but based on the code section she presented, it is talking about sellers and other entities, so that definitely needs to be clarified. Also, too, some of the other points that some of the members have made, the lack of knowledge is an offense. And I've worked drugs before, and I went undercover before, and they don't, run down a list of ingredients when they're passing out drugs to the distributor. So the burden of proof and charges, or how that's actually utilized on the street, I'm just trying to understand, because there's a testing portion of this. And once the arrest happens, you have to test the drugs to see what's in there. So the first question is, do officers on the street have the testing ability to test for fentanyl in whatever test equipment they have now? I know they can do cocaine and a few others, but I'm not sure fentanyl is a thing and what that cost would be. Secondly, so just because you distribute it, to her point, and you're going to be convicted of murder if fentanyl's in it, whether you knew about it or not. Mm-hmm. And like I said, to the first point of you getting the drugs from whomever, they're not giving you a list of ingredients. So even if you think you're distributing something that is, for instance, when we work drugs and there's marijuana, sometimes marijuana is laced badly, but they're not selling cocaine, because surprisingly enough, some drug dealers, they don't want to be the cocaine guy. They want to be the marijuana guy. And so they think they're actually doing something better. But what you find is the intent. Mm-hmm. And so the intent is a problem here. So to her point, she doesn't know where it came from. She's thinking she's doing one thing. Granted, drug dealers are not good people, like, want to establish that. But when it comes to the law and how it's applied and how it works, it has to make sense. And so I'm not even sure about how the charges would work. Would you get one charge upon arrest, upon whatever level of testing, the additional 2 years plus murders added later, and you're in jail? Like, what? Like, so I'm trying to understand what the life cycle looks like, because it really doesn't. Like I said, I support the bill overall, but I'm trying to figure out what it looks like and how tough it'll be trying to get the officers on the street to figure that out, in prosecution, just what that would look like. Can you kind of walk through that part?
Well, obviously, if they have a trunk load of say marijuana and it's all laced with fentanyl, like you said, testing wise, they would be charged. But then you have to, marijuana will probably be tougher than a lot of other, like heroin or something like that, because they could probably, I'm not 100% sure. I'd have to, obviously get somebody that's expert on testing, but I would think that they could probably test the heroin, were it like a, certain type, mixture. I don't know, to be honest. I see what you're saying, but I think if they have a large amount of heroin or marijuana in their vehicle and they're selling it at a place that people are dying from it, they should be charged with homicide. And just saying that you don't know about it, even though you got a trunk load, which 4 grams or more. So, I guess it would put a lot more work on the law enforcement officers.
Yeah, so the follow-up, I guess, would be, how do you know that you died of fentanyl?
Well, normally, I mean, you go into cardiac arrest because it relaxes everything, and you just...
Because cocaine gives similar...
Well, cocaine to overdose. Like I say, I'm not a medical doctor by any stretch of the imagination, but cocaine to overdose on it speeds up your heart, and usually takes a large quantity unless you got a heart problem or something like that. With fentanyl, it puts you to sleep. That's what they use it for. So it essentially just relaxes your heart to the point of it stops beating.
So I guess so I think the ultimate thing is, with this bill, I feel like removing other contributing factors is making it assume that regardless of whatever your situation is, if there's fentanyl in anything, you're getting a murder charge when you're not sure about what actually caused you to die. And that's where I'm trying to work it through. Like I said, I like what you're trying to do. I'm just trying to get you there.
Right.
And I'll pass it off to somebody else.
Well, and to your point, I think you're actually right. If you did, to be honest, if you get caught with fentanyl in anything, it should be a very extreme punishment, because there's, obviously heroin and crack and all that's bad, but fentanyl's a death sentence. So to get caught with fentanyl, period, because it's obviously used in the hospital setting, should be a very stiff punishment.
Who's number 17 over there? Vice Chairman Reeves.
I'm glad to work with. I'm glad to work with Floor Leader Hong and anybody else on legal language. If we're not ready to do that today, if somebody wants to move to table later on and work on that, glad to do it, because I want to see this pass. But one point I'd like to make. 161331 is referenced, I believe, on section, 161330 is referenced on section 3, but 161331, trafficking in cocaine, illegal drugs, marijuana, methamphetamines. Subsection B has provisions about opioids, and then mixtures of opioid-related materials, and this sort of beefs that up. And there's one thing in there about the prosecutors, if they have someone who's a witness to that crime, and they give substantial assistance identifying, arresting, convicting any accomplices, accessories, co-conspirators, or principals. What you mentioned, Representative McCollum, that would come into play about sort of going up the chain to find out who is trafficking in this fentanyl. But, I think that's something, if you look at it, safe harbor provisions and a detailed statute that would, add a little bit more clarity to the issue that Representative Hong brought up, and maybe having that a little bit more explicitly worked into the bill might be a good idea. But that is one thing that I think addresses some of the concerns. So 161331B and other provisions of that statute, and tying that more explicitly into this bill, because we got to do something about this fentanyl.
Thank you.
Is that a question?
Have that statute, have you currently worked that in the bill, or would you like to take more of a look at it?
I would be open to taking suggestions for sure.
Looks like that's all the questions we have. Folks signed up to speak to the bill. We have Pac, Mr. Scandalakis. Representative McCollum, if you just want to slide over a little bit, give them a little bit of room.
Thank you, Mr. Chairman and members of this committee, and I appreciate Representative McCollum, and I've had conversations with him, so he's not going to be surprised by my position on this. And my position on this is we don't need this legislation. We have what is called felony murder in Georgia. Felony murder is during the commission of any felony. You cause the death of another that results in that person's death by proximate cause. You can prosecute for felony murder. So if I'm distributing or selling, because a lot of times the reason we have the terms distributing and selling in the statute is to prevent a defendant from saying, well, I wasn't selling, I was just giving. I was just handing it to him, or, I'm not the distributor, I'm the seller. But you can already charge felony murder if during the commission of a felony, distribution of a controlled substance, sale of controlled substance, you cause the death of another. you can charge them with felony murder. And in fact, the DAs are doing that today. I took a quick poll last night. Of the poll, I had a quick response from 21 DAs. 16 of them do use the felony murder statute, and in fact have felony murder indictments. And they are pending now that they have filed, obviously, during the pandemic. Of the others, would you use the felony murder statute if the facts permitted it? They said yes. Almost all the DAs said yes. So we have the ability to do that. You know, there was a great question over here about the distribution, you know, and I know there's one case that people have talked about a lot up here in the hallways because they've spoken to me about it, was you had two people who decided to go out and purchase cocaine one night, cocaine or methamphetamine, I'm not sure which one. And they went on an all-night binge to use these drugs. The next morning, the man woke up, the young lady was dead. She died as a result of an overdose. He called 911 to try to get help. So now he is obviously under the safe harbor that he has made that call. So, you know, there's no prosecution for him. But they both ingested that drug voluntarily. So as a career prosecutor, and just for those of you who don't know me, because I know many of the members of the committee here, I've been a prosecutor for nearly 40 years. Started in 1984. Was an assistant DA for 7 years, then became the elected DA for 25 years. I've prosecuted cases under felony murder. And I don't want y'all to think that somehow I'm supporting fentanyl, because I'm not, okay? All of us, and I understand, we've all seen what drugs have done to our community, not only to the law-abiding citizens, but those citizens that, other than for drugs, wouldn't be committing crimes. And I've seen them wreck thousands of families. So I know a little bit about this fentanyl. I know a little bit about cocaine. I know a lot about addiction because I have family members with addiction. So I know, and I think the goal is good. I think you can accomplish the goal in other ways. If you want to increase the penalties on fentanyl, you can do that. With possession of fentanyl, that you intended to possess it. The distribution, if we had somebody who had multiple grams or multiple ounces of fentanyl, I can guarantee you we'd charge them with trafficking. In fact, just before I took this job as executive director with PAC, we had such a case, and we did exactly that. So we have the laws on the books. I have an expert here, Sheila Ross, who is a resource prosecutor, the Prosecuting Attorneys Council. I'd like her to speak before we open this up for questions, so we can kind of keep this thing going. And I also have the district attorney here, Samir Patel, who now has a current indictment with felony murder. We got plenty of statutes on the books. I know we do. When I started, the entire criminal code was in one volume. Today it takes two. It was. And basically I could tell you, if somebody asked me today what the penalty was for any type of offense, in '84 I could tell you. Today I would say, I need to go research it, okay? So I'd like y'all to hear from Sheila Ross, and I'll stick around for questions if that's okay. All right.
That's fine.
Hello. Good afternoon. My name is Sheila Ross. I'm the Director of Capital Litigation for the PAC. I'm also a career prosecutor. Have prosecuted homicides in San Francisco, California, Jacksonville, Florida, and most of my career I spent in Atlanta, Georgia, running the Major Case Division, the Cold Case Squad, and the gang units, where we prosecuted about 60 to 80 murders every year, and had the pleasure of working with Representative Miller, who I know for a fact is an expert homicide prosecutor herself. I have been asked to be here today by my boss to basically share with y'all my insights on this bill. I think it is well intended, and I applaud Representative McCollum for wanting to tackle this. This is bigger than murder. We had about 170 homicides in the city of Atlanta last year, twice that in OD deaths. It's not an issue, though, and this is an issue that affects everyone here. It is rural, it is urban, it is suburban, and it is terrifying. I've have had the opportunity since I left Atlanta to prosecute murders in other sections of the state, and I know there's a very big difference between rural murder and city murder. But in this area of death, we are all aligned. And so something should be done. But our felony murder statute is flexible. It is based on the common law, and it allows us to prosecute these crimes right now. We have issues prosecuting the crimes. They're difficult. They're difficult murder cases. And Representative Neal, I just heard as a law enforcement officer, so she knows. When the police respond to a homicide scene with bodies riddled with bullets, they treat that very differently than when they respond to an OD. And what we have tried to start doing at PAC, and we started in 2020, we started with an OD homicide course. We need more of that. We need more resources. We need more training. We need to train judges. Judges don't like when we charge felony murder with the underlying felony being distribution of fentanyl or heroin or cocaine. Some of the problems that we're having with these cases can be solved with thorough investigations, but we don't have the resources. We don't have the manpower. These are very specific types of murder that take a different type of investigation. Your average homicide detective works murder. They don't work dope. These types of cases need to be worked in conjunction with narcotics. The investigations are different. Most of these drug deals are done with this. And so it takes a lot of digital forensic analysis that is just very different than a homicide case. So I applaud you. It's a wonderful idea. I hate to tell the legislature that we don't need a bill because I'm a greedy prosecutor. I'm like, yes, we need more and more. But we don't need this for felony murder because we have a beautiful, very flexible common law felony murder statute. But we do need help. We need help. And we need training and lots of other resources. Thank you.
And just stick around for some questions.
Sorry, I'm not used to that. I'm used to asking the question.
District Attorney Samir,
Okay.
Thank you.
just tell us where you're from and what you do.
Thank you, Chairman, for the time today. My name is Samir Patel. As Mr. Skandalak has indicated, I am the District Attorney of Bartow-Gordon County. It's a two-county circuit about 30 miles north of us. But I kind of have an interesting background. I was a public defender for 5 years and then a defense attorney for 12 on top of that. So I was 17 years as a defense attorney and 2 years as a prosecutor. I also commend Representative McCollum for passing this bill. I, too, have a family friend who suffered through the same thing. And so from my perspective, and I can't speak for all the DAs, but all the ones that I've spoken to, we take this very seriously. In fact, we have, it's going to sound small here in Fulton, but right now we have 13 pending murder cases. Of those, 3 of them are the fentanyl murder cases. And so we've tackled that with the vengeance. We've collaborated, our drug prosecutors and myself have collaborated with our drug task force and our local law enforcement agencies to say that when you have this situation come up, this is what we need to prosecute this case. The statute as currently comprised does not prohibit us in any manner from prosecuting these cases. As a defense attorney, we have one starting on trial on Monday, and we have 2 more behind that. I kind of contemplated what some of the defense arguments are going to be, and based upon our research, we fully believe that the way the statutes have been interpreted through the Supreme Court, we are in good footing to proceed as far as prosecuting these cases under the current felony murder statute and don't see it being an issue.
Thank you. I'll open this up for questions from members of the committee. If y'all want to just sit here around the table and play musical chairs here. We'll have some questions from members of the committee. Representative Kendrick.
Thank you, Mr. Chair. So to be clear, thank you that was my first initial question, which is sort of what is the current status of the law right now. So to clarify that we have felony murder on the books right now that's being used, but the difference between Representative McCollum's bill is the knowledge portion of it and the intent. So currently right now you still have to have knowledge that fentanyl was in the controlled substance, but his bill would remove that requirement.
Well, what you have to have under felony murder is the distribution of a controlled substance, which is the proximate cause of the death of the individual. So maybe it's fentanyl, maybe it's cocaine, maybe it's a high dose of methamphetamine. But obviously a jury wants to know what the defendant knew, because unlike Ozark, where everybody knew what kind of drugs they were. Well, I mean, it's unlike Ozark, where everybody knew what kind of drugs were coming in the cartel. The fact of the matter is, by the time it gets to the street level that we're dealing with, it has gone through hundreds, multiple hands, and we're dealing with, I've been a member of Metro Task Force, GBI Drug Task Force. We try to get the big seller. Sometimes the big seller might be in Texas. So we're dealing with the federal authorities, trying to get the feds involved. Sometimes the big seller might be in Florida. But these distribution centers are all over the place. And they are making sure that when it goes out, it has touched a number of hands. In fact, one of the things we're dealing with now is you don't have a lot of hand-to-hand cash sales anymore because they have Cash App, they have Venmo, and they're ahead of us. Every time we make a one step forward, they take 3 steps forward, and they're ahead of us. We all, quite frankly, we have, and Sheila knows because she's we have inmates who are dealing with mass amounts of fentanyl in the prison system. Yesterday I was with Sheriff LeBlatt. He showed me where they had confiscated huge portions of fentanyl in the prison system, in the Fulton County Jail. So it's a huge problem. So did that answer your question?
So lack of knowledge of it being a part of a controlled substance is currently not the law right now.
If it's a controlled substance, it caused a death, and I can prove it, then I can prosecute it.
Okay, thank you.
Because you're selling a controlled substance, regardless of what's in it.
Right.
You're selling it.
Correct. Okay.
Or distributing it, or even giving it away.
Number 11, is that Representative Hong?
Thank you, Mr. Chair, and thank you for your statement. So, just to clarify, are you in the position that Section 2 is unnecessary, or you don't think the bill just as a whole is unnecessary?
I think the Section 2 is unnecessary. I think if y'all want to, it's a policy question whether or not you want to increase the penalties for possession or distribution of fentanyl. And you can handle that without going into the felony murder statute.
Thank you.
Who's number 14? Representative Neal.
Thank you, Mr. Chair. Thank you for your feedback. So a few questions. One, how are you currently proving fentanyl now?
Toxicology. So the GBI toxicology section, or in Fulton. Sorry, I'm not allowed to talk usually. Toxicology. So we use forensic toxicologists. Depending on the agency within the state, it might be the GBI. Fulton County uses an outsourced lab called M&S. But everybody would have to use a toxicologist, a forensic toxicologist. And sometimes that's why this is not a matter of law. It's not a law question. It's a fact question. We do have to prove that the felony was inherently dangerous. Next time I have one of these, I'm just going to call Representative McCollum because he just proved that for us in his opening statements. And then we also have to prove that the felony was the proximate cause of the death. And so we do that with medical examiners and toxicologists. We need more of both of them. The GBI only has 9 of the 18 that they need. Fulton County is down medical examiners, and we need more toxicologists. Many of these cases, you will have multi-toxicities. Right. So your victim will have cocaine, heroin, fentanyl, and that becomes a question of toxicology expert opinions, and so we need resources to pursue that.
So are the medical examiners able to determine which drug happened first?
No. Sometimes the toxicologist would be better at that, just depending on the levels and the metabolites on board. But these are very fact-sensitive investigations. So a lot of times, and we have very upset parents, and I know Samir has dealt with them, and I know Pete has dealt with them, and you've dealt with them, and I know Ms. Miller has dealt with them. Anyone who has ever been in this field, we have very, very broken, rightfully so, broken parents who want us to do something about it. And it's not the law, and sometimes they misinterpret that. It's the facts. It's that these are so investigatively intense in a way that an average murder case isn't. Right. And so they take time, and they take a great deal of resources, and they take detectives, judges, prosecutors, and defense attorneys that know this issue. And we don't really have that here. We don't have that built up in our state.
So how do you get a fentanyl charge right now if we can't determine in which order?
Because we indict it in a way that gives us that flexibility. So the indictment would read, let's say it's a multi-toxicity case, and let's say our decedent had fentanyl and heroin in their system. We would indict it with distribution of, actually Samir's case on Monday is distribution of fentanyl disguised as heroin. That's actually in the indictment.
Okay.
And so that's what the jury is told.
Okay.
That's what our evidence is, and our evidence is from the victim's phone and his text messages between him and the dealer, that the victim thought he was getting heroin, but in fact the victim got straight fentanyl. And it was
Okay.
the fentanyl that killed him. So it's how we indict it with the language in the indictment. And we've indicted it all kinds of ways.
Could you always package it up?
And because our statute is so flexible,
Right.
it permits us to do that. And so we indict it in a way where the jury understands exactly what's going on through the indictment.
Gotcha.
Once we train properly on doing that. Because
Okay.
it's a training issue. It's not easy to do.
Right. All right. Thank you.
Who's number 16 over there? Or 17? We'll let Representative Fleming go.
We need to get a Sharpie, Mr. Chairman, and write the numbers right here so we can answer. I always want to tell the chairman what he wants to know, but I'm at a loss. My question is for Mr. Skandalakis, and as I understand your answer to the previous question was, if we strike Section 2 and leave Section 3, it causes no problems for you with prosecution. Is that correct?
If you are just increasing the penalties for possession of fentanyl, that doesn't pose a problem.
And that's my question to you. Is that what Section 3 does?
I'll have to turn to Robert on this. Where's Robert?
I don't know if, Robert, if you can hear us. Feel like I'm one of them preachers on Sunday night. Anybody out there in radio land that can hear us?
If I may let Ms. Travis answer it.
Sure.
She's-
And Miss Travis, we all know who you are, but if you just introduce yourself, tell us who you will.
Good afternoon, members of the committee. My name is Jill Travis. I'm with the Georgia Association of Criminal Defense Lawyers. The problem with Section 3, Representative Fleming, is that it conflicts with current law. If you look at 1613-31B, the prosecution for trafficking in fentanyl is already present. And this conflicts with whether it's possession or sale or trafficking. So I think there's more drawing board work to the point that the committee is interested in increasing penalties. That's obviously within your purview, but the problem is the bill as currently drafted is conflicting with current law.
So you're the best legislative counsel I ever worked with. You saying you can fix this. Is that right, Ms. Travis?
I'm not sure that I'm going to up for that task, but
I know you're up for it. The only question is, will you?
I just made the comment over here that, see, we can work together.
That's what I would like to see.
and I can, if you don't mind, I can just save my testimony to say, I agree with these people. I haven't had a chance to say that to Representative McCollum, but it's always really lovely good news to say, hey, the law is already there. And in this particular instance, the law is already there. And if there's something fine-tuning that needs to be done, a tool that needs to be sharpened, we understand that might be coming, but I don't think it's in this fashion right now. Thank you, Mr. Chairman.
Thank you all. Jill, Vice Chairman Crowe.
I don't know what. Yeah, this whatever number you just clicked is the one this is. We don't have any numbers on these. So to your point about the conflicts that Representative Fleming was talking about, would it be all of Section 3 or just portion C on line 43? Because that's where it talks about 28 grams or more, which would be a trafficking amount, correct?
So the problem is 161330 is the statute that we deal with mostly with possession, sale, distribution. 161331 is when we get to trafficking. And so what this bill has done is it's shoved the trafficking into what's in the possession and distribution and added some features that aren't present, and you're going to have conflicts in the law in the rule of lenity that would apply. If you look at
Yeah.
161331
When you get to 20
B
grams of
allows the
road traffic
prosecution,
amount.
and you have to look up the cross references to know that fentanyl is covered under B already. And all of the revisions that are in 161331, or some of the revisions, were tackled in criminal justice reform a few years ago to set up the schedule to make, different punishments for depending on how many grams you have, and increasing that based on the punishment up to mandatory minimums.
Representative Hall.
Thank you, Mr. Chairman. If I can make a motion, if I may.
We're not in that posture yet. Just hold on. Any more questions? Jill, I know you'd signed up, or you?
I'm good.
All right.
Thank you.
Number 14, Representative Neal.
Thanks. I think this mic is out.
Representative Reeves.
All right. Representative McCollum is a first responder and Marine veteran. We've got experience from the prosecutors and now criminal defense lawyers. Rather than, do not passing this bill, if this committee tables this bill, is everybody willing to work and look at this and see if there's anything we can do about fentanyl that's not in the current law?
Again,
Come on, man.
I don't know.
You're not going to sit on my lap.
I'm not going to sit on that. Ms. Travis and I are close, but not that close. Again, I think it's a policy question whether or not you want to increase the penalties for fentanyl. I am in favor of that, possession of fentanyl. I will work with Ms. Travis and bring something to you through Mr. McCollum, through Representative McCollum, excuse me. We'll be we'll be glad to do that. So if that's what the legislature wants, we can work on that together. And I told y'all in 1984 I would have known the answer to Chairman Fleming's question. Today, with all the code sections and different, I had no clue. Thank you, Ms. Travis.
We got a question from Representative Muggle.
Thank you, Mr. Chairman. So in Section 3, would increasing the penalties make any difference in prosecution or intent to distribution?
Well, yes. The short answer is yes. The next answer is, obviously we have a prison population that is there, but fentanyl is a serious problem. So again, that's a policy question for y'all.
May I speak?
Is this in response to what Representative or Vice Chairman Reeves said, or?
Well, I just have one last comment. if
Okay,
that's
just
okay.
hold that until
No.
discussion.
Yes, sir.
All right. Now we're in a posture of discussion from members of the committee on the bill. Discussion on the bill. All right. Now I'll entertain let me rephrase this. What's the will of the committee? Representative Hong.
Mr. Chair, I motion to table this at this time. I think the intent is good. I think if we can work on it a little bit, I think it needs work.
Okay. Got a move in a second. Representative McCollum, I'll let you chime in on that.
Well, I just have one last thing to say. The definition of insanity is doing the same thing over and over again and getting the same results. I understand these people are experts, but it's not working. So I feel like that we need to do something. And it was perplexing to me. I'm not an attorney by any means, but she said that judges do not like charging felony homicide. Well, if I'm not mistaken, judges are the ones that interpret the law. So if they're interpreting it that way, that they don't like charging felony homicide, maybe that's something we need to look at on, making that language a little more defined. So, and then the other thing, we have 41,000 deaths already, and it's climbing. So, thank you.
Thank you. Any discussion on the motion table? All right, got a move and a second. Move and a second. All those in favor say aye. Aye. All those opposed, no. All right, it's tabled. Thank you. I know the hour is getting a little near to everybody wanting to cut out and partake in different activities, but if y'all indulge, we're going to recess for 5 minutes so we can go to the restroom. We'll be right back in 5 minutes. I have 4:27, so 5 minutes from now. All right. If everybody come to order. Everybody come to order. We're going to get started. Sooner we get going. All right. Now we have before us House Bill 196. Members, I believe you've got a substitute in front of you, Chairman Powell. Just to be clear, we've got LC number 280569S, as I understand it.
0569S, that's correct.
Yes, sir. And if you'll just pull your mic a little closer there. Thank you.
Very good.
Chairman Powell, welcome. We're glad to see you. Glad to be in the land of Title 16 with you.
It's always been my pleasure to appear in front of this distinguished committee over the years.
Yes, sir.
I'd like to, before I start this bill, what's in the bill, I think it's a necessity to maybe give a little visual optics of what's happened. This isn't a bill like the one you previously heard about changing the statute to do certain punitive things. This is a bill that corrects a situation. 7 years ago, this legislature passed legislation to allow the issuance of medical cannabis cards. We passed that because over a period of time, it had become a realization and a reality that medical cannabis, or the use of cannabis in certain settings, was of a benefit. And we saw them bring children and sick children and veterans and everybody under the shining sun. And I was always very plain spoken. I always said, not as an insult to the pharmaceutical industry, but anything that God lets grow natural has got to be better for you than something produced in a laboratory. And I said that because I've seen the effects of opioids, and I've seen, and I don't disregard the fact that they may be good, and a lot of the manufactured chemicals are good. But this legislature finally saw the wisdom, as did so many other states across this country, about the benefits of regulated cannabis. Well, it rocked on, and that was some 6 or 7 years ago we issued those cards, and then we had a study committee, and we traveled around the state, and at that time, and we had, you may remember Representative Allen Peake that made such an issue of medical cannabis for children, and the children that were brought to the Capitol. And in that process, I learned a whole lot more during that process. And I learned that we had families in this state that would have cook-offs, like Tupperware parties, on Saturday mornings that had sick children. And they'd go buy marijuana, and they would cook it and press it and do all that thing to squeeze the oil out of it just for their children. I've met people that had autistic children that it actually did good for instead of putting them on pharmaceutical medication. We've seen children that had the stutters or the tremors or just some of the most horrific things that you'd ever seen. And it reached out and it touched the hearts and the souls of the members of the legislature. Well, then 3 years ago, we went forth with the legislation. And I'm going to give you a lot of this background so you'll understand where I'm going in the bill. But at that time, there was the committee, the study committee had recommended 12 licenses. And then as the bill was put in and the legislation moved forward, it got to the Senate. And of course, as is typical of dealing with our brothers and sisters over in the Senate, if they could make some different changes that created issues, it created issues. They wanted 3 licenses to be issued instead of 12. And the negotiated settlement between the House and the Senate was to do 6 licenses. 2 would be Class 1s, which were up to 100,000 square feet. And then 4 Class 2s, it would be 50,000 square feet in the area that the licensees could grow. It set up a cannabis commission. And let me pause right there because I do want to make an apology because my temperament over the years of serving up here, sometimes I'm very plain spoken, as a lot of y'all may know, because my sharp tongue might have been, some of y'all may have been the victim, and I don't mean it with any disrespect. But I'm one of those people that I think that legislation, that we have a duty as legislators to pass things for the betterment of this state. And I've been very uncomplimentary to the Cannabis Commission. And I do not deny that fact, because I'm irate to the fact that I believe that this legislature, that we have the legislative authority, and when we pass laws, then we have a right to get answers. Not only as a legislator, no matter what political party that you serve in, you have a right to get answers, especially from the bureaucracy of this state, much less to a standing committee or an assemblage of fellow legislators. Well, the Cannabis Commission started their work, and I'll agree that there were probably some flaws in the legislation. It created other things. But there were some close to 70 applicants. You know, quite frankly, we had everybody in the world, from chicken farmers who wanted to start growing pot in their chicken houses to the out-of-staters. And I want to remind you that one of the first things that we did in that bill was we said these were supposed to be Georgia-based companies. Quite frankly, I don't know how many of them were really Georgia-based companies. But I'm not getting into that argument at this point. But we had about 69 or 70 applicants, and then the process started. Well, it drug around, and the commission themselves came up with a process. And I'm not supposed to know this, but I have, because I'll ferret out through questions and answers of the folks who didn't get a license, and through the attorneys who have since sued the state. And what we found was that there was an interesting process there. We don't know why, but the appointees who had affiliations to certain schools where big donations were made by certain license applicants, we don't know what, and I can't say that there was any wrongdoing, and I'm certainly not going to say that there was or make any accusations. But if anything else, it was a major show in how government shouldn't work. The process that we saw by ferreting out in the Regulated Industries Committee was that of all the applicants, there was a numerical score that was posted to each question. And there was a series of questions for every applicant, for those applicants for a license to answer. Security, location, jobs, minority participation, distance from certain institutions of schools, affiliations to any type of university. You name them. There was just a series of these questions, and they were graded on a point system of 1 to 5, I do believe. But when we started looking at all of these, it was absolutely amazing to me that 30 of the applicants could post the same answers. Some would get a 0, some would get a 5. And when you see that type of operation, you have to ask your question, what in the hell is going on? Especially when you call the Cannabis Commission, and to this day we've never met in a committee setting the members of the commission. I will say for his benefit that the director of the commission, Mr. Andrew Turnage, who's a nice guy, and I understand he's the director, he didn't control the board members, so I'm apologizing to him. I've been rather irate because when he appeared in front of the Regulated Industries Committee and we asked questions, he had a standard pat answer, I can't answer that. The legislation says we can't divulge anything. Now, I tend to disagree with that because when a standing committee of the General Assembly asked a question, we deserve to get an answer. I tend to believe that a lot of that might have been based on maybe some misinterpreted language in the legislation. Might have been by devise as it came out of the Senate. That might have been dealing with trade secrets. Quite frankly, as a legislator, it's none of my business about trade secrets of any of these folks who are growing and processing the medical marijuana. But then you had the next step. In the legislation that was passed, there was an appeal process. And I guess, thank goodness for that. because as they continued to do their business in the silence and the privacy behind closed doors, and I can't emphasize when I say behind closed doors enough, but during that process, they came up with some tentative, quote, tentative selections of who would be granted the 6 licenses. Well, because of that, I think at the time, if my memory serves me correct, there was 21 protesters that could protest the proceedings, and they did so. Then in this last year, within the last year, and some of y'all that were here last year may remember some of my comments from the well and the predictions that I made. I'm not an attorney, but I have been around. I was born at night, but not last night. And what I had said at that time was that from having discussions with these folks that had made a major financial investment to get into this business, that they were going to file lawsuits. Y'all may remember that from the well of the House last year. Well, session came, session went, nothing was done. Since the session ended last year, there has been a consortium of lawsuits that were filed against the commission. And I think someone's here to testify, maybe one of the lawyers that can lend a little bit more appropriate legal discussion, since I'm not an attorney, but it tied the system down. So there was some restraining orders that were issued, and the restraining orders got served on the Class 2 licenses, and that held them up. The 2 that were granted Class 1 licenses, they skated out, and they were issued the license by the commission before the restraining order took effect. So what you've got is you've got 2 of the 6 that they're building out. They're getting ready to start production, and they're growing. You've got 4 that are were tentatively approved. Whether they were the best or not, I can't speak to that, and I won't speak to that. But then they're not. But then right now what we've got is we have found that there are 8 other legitimate applicants that have entered into the litigation that's before the Court of Appeals right now. And if there's an attorney, I think they'll be here to address the legalese to that. But to me, the issue is more at hand about the ineffectiveness of the acts of the General Assembly. I've heard some people say, well, just let the courts decide. Well, ladies and gentlemen, that's an insult. That's an insult to me, and should be to each and every one of y'all, that we're going to govern by letting the courts legislate. We need to fix the system. We need to fix it, because we have citizens in Georgia, whether they're veterans suffering from the malady of the diseases that they have, both mental and physical, whether it be for the children that you saw, that I saw the House of Representatives stand in unison and applaud those children and the families that were in the gallery when we passed the bill. That's what this is about. The bill didn't pass last year, and what has been changed this year has made it somewhat more, maybe more palatable. But I'll also give you another statistic. That one of the things that was amazing to me was that while we, or the commission, or the committee at the time had recommended 12 licenses, that if you look across the country on a population basis, Georgia, based on our population, would actually qualify for 20 of these processors. Now, that's not what I'm recommending in here. I'm recommending a fix to get this thing up and going, and at that point, I'm going to go into the bill. If you look in section 1 on page 2, the most important, if nothing else, one of the most important parts of this bill is this language puts the Cannabis Commission under the Administrative Procedures Act and the Open Records Law. Let me just tell you something. Nothing good comes out of government behind closed doors. Nothing. Because you don't know who's responsible and whether things are being done the right way. Now, I saw a newspaper report that somebody with the First Amendment Foundation or whatever said, well, that ain't going to fix it because we didn't repeal a certain section of the law. Well, I would submit to you, ladies and gentlemen, it does, because this is the newest law and the most recent, and it spells, quite frankly, that the Cannabis Commission falls under the APA and opens records. And the lady that for the First Amendment Foundation, I wish she'd taken time to given me a call, and I might could have listened, and she might could have advised me otherwise. Section 2. This is the permitting. One of the things that we saw was that there were 5 dispensaries on all the 6. Well, that's only 30, quite frankly, 30 dispensaries. In a state of the size of Georgia, you'd have some people that would be driving untold distances to try to get to this with their medical card to get whatever type of the medical oil that they needed. So this adds one more to them. And it says that wherever their dispensary, wherever their growing operation is, they can have a dispensary at that location. Some of the ones that, some of the medical grow facilities we saw, quite honestly, every one that we visited over the period of years, they all had a dispensary on the front of their locations. So this adds another, so each of the licensees would have 6 possibilities of dispensaries. Section 2, page 4, lines 79 to 80. This would allow for each of these dispensaries to sell not only the medicine that they produce, but they could also sell the medicine produced at any of the other grow and dispensary operations. Now, I will tell you why we have put that in there since in the last year. It's been quite amazing, the science that I'm seeing with the growing of this stuff. I've had people that's met in my office, and it's just amazing the cross-pollination and this kind of stuff that, quite honestly, they're growing this stuff a lot different than it was when I was in college. No, I'm sorry. Oh, but the statute of limitations may have run out. But I saw some of the formularies that they use of mixing CDB, THC, mixing different strains that actually have an effect on different types of diseases. And that's quite amazing to me. But it gives me pause about agriculture and about technology, that now we're using what God lets grow natural to be refined into something that's of a benefit to the sick and the disabled and those who need it. On Section 3, this provides for legislative oversight, real oversight for a change, not just 2 members of the House or 2 members from the Senate. It creates the oversight to the Cannabis Commission, the same as we do to the lottery, and that would be the members of the House Regulated Industries Committee and the members of the Senate Economic Development Committee. Those 2 would form a joint legislative oversight committee under APA to see what rules and regs and to see the intricacies of the work that they're doing. Section 4. Section 4, 5, and 6. This is the guts of how to get this going. Right now you've got 8 of the protesters who are involved in litigation in the Court of Appeals. Until those are resolved, there'll be no growing in the state of Georgia. Now, unless you are adamantly opposed to using medical marijuana or the use of it, well, you probably don't want to vote for that. But if it's tied up into the Court of Appeals, I'm told, being a non-lawyer, that we could be looking at spring or summer or whatever before that's resolved. At that time, that Court of Appeals, they might, if they decide with those who filed, they might throw the whole process out that smelled like an old pair of sneakers on the granting of licenses. If it is, to me, that would create another set of problems. That you've got 2 that have been licensed under Class 1 that's made a sizable financial investment in their locations, And by the actions of the court, they could throw that out. They could just throw the whole thing out and start all over from scratch. Something that I have concerns about, because we need to move forward for the sake and the benefit of the people of Georgia that need this type of a product. So what we've recommended, and we've looked at the formulary, some of the 8 protesters that are involved, some of them applied for Class 1 licenses, some of them applied for Class 2. They can't have them both. They can only have one. So if you'll look in sections 4, 5, and 6, you will see in there that there's a system that would allow for the issuance of whichever one they want. But at no point there would be more than 14 licenses granted. That gets it out of the courts, because in this process to grant a license, once they're granted a license, they have no reason to be in litigation. That, ladies and gentlemen, is what fixes the system. There's one small part in here for a former member of the House, and that was it was added into for the disease that could be make you qualify for a card, for a medical cannabis card, and it is ulcerative colitis. And don't ask me to get involved in it. I don't have it and don't know much about it, but it don't sound like nothing I want to talk about. But I presume that Representative Walensky thought enough about it when he put it in, that apparently it must be a one painful booger, whatever that is. So that, ladies and gentlemen, is what this bill does. This is a fix. Most importantly, it puts it under APA so that you can ask questions. You can find out, you can have oversight, and we move forward to get this process underway, to get these people into business so that at some point, those people who are deserving it needs this type of medicine, that they'll have it. With that, Mr. Chairman, I'll be glad to stand for questions.
Thank you, Mr. Chairman. Chairman Saines.
Thank you, Mr. Chairman, for bringing this bill. I'll let the attorneys in the room ask about the technical process first as a dive, but I want to ask you about, you've talked about it in your testimony. What is the primary policy intent? Because I see two items that, depending on your viewpoint, might be more worthy than the other, but is this to address the absolutely botched execution from the commission in terms of handling licenses? If so, is the cure of that also going to create an issue of, we're creating more licenses without knowing a baseline in demand, so are we going to have an excess of supply in this state of medical marijuana, and how do we address the rate? How do we know that the appropriate hands, I think this body has made very clear we want those with those medical conditions to get it. What we don't want is a pathway for those who are underage, those who don't otherwise need it, to make it easier for them to obtain it illegally through this process. So can you help shine a line?
Well, I'm not quite sure where to start yet. So many questions added into it, but I would certainly say that the gentleman knows from where he speaks in his questioning. But I think as a leap of faith, all I can tell you is what other states have done. I can tell you what was the will of the original medical cannabis study committee. We recommended 12. When it got to the Senate, they wanted 3. It was agreed on at 6, which was probably under anyway. If you look at the state of Florida has got double the population of Georgia. They have 40 licensed operations. You look at a lot of other states, it's generally what we have found is that population figure in some cases is about the same, except in some of the states there's a lot more of the producers. Now, would 14 be enough? I don't know. But I would say that that's another issue for the General Assembly to deal with. If it's the will of this General Assembly to say 20 or 18 or 16 or whatever it may be, that's the will of the General Assembly. I'm only dealing with specific numbers, that 14 would be the head count to do licenses with a maximum of 14, whether they be Class 1 or Class 2, and that gets us out of litigation. That pulls the state out of it pulls us out of the Court of Appeals, the license could be issued, and then they could go forth.
So what I'm hearing is your equation of demand is based on the models of other states' calculations.
Correct.
Okay, thank you.
Correct.
Chairman Silcox.
Thank you, Mr. Chairman. First of all, Mr. Chairman, I applaud you for your request to resolve these issues, because I do think this is a huge problem. And I was there, and I did vote for this bill and stand with all the General Assembly almost in unanimous to applaud this action. That being said, I was a consultant on with one of the companies that was applying in this past year, and they actually went out and did a very serious study with Bain, spent over $1 million to get the study done, and my concern is that we do this right. My concern is that we get this, that this industry will be viable, because as a cancer survivor myself, you know, I know of people that really need this. I really do. So I empathize, like I said, and I have the highest respect. That being said, the results of this study showed clearly that the best way for this industry to be viable is to open up the licenses gradually. And my understanding is that for every square foot of cultivation, every square foot will basically take care of one patient a year. Currently, because they have the two 100,000 acres of cultivation,
Square feet.
Square feet, excuse me, because they have those opened up, that would be 200,000 square feet of cultivation, which you would need 200,000 patients for that to be full. We have approximately 20-something thousand people on the registry now. And if we can let this open up gradually, if we can let this open up gradually to the other licensees, it's expected that the next appropriate time to allow this industry to be viable would be in year 3 or 4, based on this. So I respect, like I said, tremendous respect for you for bringing this, and I do want to fix. But I want this industry to survive, and if we open up these licenses to all these other people right away, then the market will be flooded, to Representative Sain's point, and unfortunately, then the black market will take over, and it will fail in Georgia. And I think it's a very, very important industry, and I want to help these people, and I want them to have a source that's ongoing, so that the industry survives. People are helped, and everybody makes money.
Well, I certainly appreciate your concern and your knowledge, and thank you for not disqualifying yourself with a conflict of interest, having been a consultant on this industry. But I would say that there's a couple of faults here. One is that the bottom line is, how do we move forward? At this point, we have been stagnant for over 3 years. Secondly, as I listen to that, one of the things that I have learned in talking to these folks is every one of these grow operations produces a different kind of cannabis that would produce a different type of medicine for different types of diseases. That's the reason we allowed them to cross-sell from one dispensary to another, so that they may not produce one grow operation may not have the right type or something for a certain disease, and another one may. So this actually gives a specialty competition to these folks. So, but thank you for your comments very much.
Who's number 17 over there? On the right side? Yep. Representative Gullett.
Thank you, Mr. Chairman. Just a quick question. So I know I understand your goal, and I do appreciate it. My question is, if our goal is to get this thing moving, and our goal to get this thing moving is to get rid of these lawsuits, if I'm a person who got a license, I got a license, or I put forward my request for this license or my bid, based on how many licenses there were available, so that I would know my return. if we expand it, have you? I don't know that you've talked to the people who have the licenses today, or the people who are protesting to get the licenses as well. Are they still okay? I mean, if I'm one of the two who's already growing of the big ones, the class ones, am I okay now having additional people in the market? Is that what I really bid on at the time? Do you have any insight into that? Maybe I don't honestly know the answer. So
again, I'm not an attorney, and I'm sure there's some that can address that issue. But the number one goal is to get this moving forward. And the power of the General Assembly is we can change the statute at any time, and that becomes the law of the land. It started at 6. If we go to the 14, we have just passed a legislative act. They're tied up in the court right now. We're going to go ahead with the 4 that were tentatively approved and then take care of the others who filed the protest.
yeah, I guess what I was trying to get at is, were the ones who were allowed to proceed go forward? Are they going to begin the cycle of litigation, and it kind of drags on, and that's that's just I don't have the answer. I just was curious if you had insight, if you talked to them, hey, yes, we're good with this or not.
I think that given the investment that a lot of these companies have made, they have stranded investments out there, whether it was consulting fees or, I know some of them that didn't even protest it were able to sell whatever they had put in or their physical structure and such, and they went on their way. But it's my belief that the ones that will once granted a license, that ends this. And then it would take an act to the legislature or someone else that may wish to get involved at that time. Mine is only a mission to try to fix this situation.
Yeah.
Because quite frankly, it's an insult to the people of Georgia that we have a governmental function that we passed that has not been carried through and is still languishing.
Yeah, and we totally agree with that.
And if you want to get an answer to that, I would advise you to call the Council Commission and see if they would give you any answers. They won't, because they're not here, because of whatever the belief is that they can't tell us anything.
Yep. Thank you.
Thank you.
I believe that's Representative Miller.
That is me. Thank you, Mr. Chairman. Good afternoon, Mr. Chairman. First of all, I just want to thank you for your work in this space. I agree with you that medical cannabis is an emerging market that should be expanding to help families and help children who are suffering. So thank you for your work, both before this particular bill and today. I also agree with you that government ought to be transparent and responsive, and so I'm very happy to see what you're doing with this. I did have a quick question for you. In terms of the oversight, can you talk a little bit about how it was that the particular House committee and Senate committee referenced in the bill are the ones who would provide the joint oversight? And it just might be showing my ignorance in this space, but whether or not that is a common method.
The oversight, the way that was picked, there wasn't any rhyme or reason.
Okay.
Regulated industries, and this isn't just my handiwork. This was all the members of the Regulated Industries Committee for the last 2 years. And I applaud those members who are still serving and not, because they rolled up their sleeves and they got involved into the weeds on this. They helped ferret out the information that we did not know, nor could we get access to. They asked the questions. Now, the reason for that is that right now, the Lottery Oversight Committee is composed of the House Regulated Industries Committee and the Senate Economic Development. So that was where the rhyme, the reason to that came.
Got it.
Yes.
Thank you, sir.
Representative Kendrick.
Thank you, Mr. Chair. I echo the sentiments of Representative Miller. I actually followed some of the news reports and things going on, and it was not pretty. So thank you so much for bringing this. My question is related to the court case, so I don't know if you can answer this, but I just want to be clear that if this bill passes and they are able to issue the additional licenses, they would give those issue those to the 8 protesters. I believe you said 8 protesters, and the assumption is that the lawsuit would go away. And because we are coming up with a legislative oversight committee, this essentially would not happen again, where, you know, we had disparities in the different applicants and things like that. Does that summarize?
In talking to some of the attorneys, that if the protesters and the 4 that were tentatively approved for the Class 2, and if the 8, if they once granted that license, there's no case for them. Their case has already been remedied because they have been issued a license. That's what I have been told by legal counsels.
Is that Representative Roberts or Chairwoman Cooper?
Alan, I don't. Is it not true that the reason the bill says that it would be the regulated industries in the House and it would be economic in the Senate is because the Senate head and chairman of regulated industry is Senator Cowsett, and y'all are at different odds against how you feel about this bill, and this is a definite way to go around him.
I wouldn't say that's exactly right. Chairman Cowsett and I have had disagreements. Chairman Cowsett was in the Senate when the bill went there. He was the one who wanted 3, was adamant to go with 3, and it went to 6 in negotiations. Now, that being said, I wouldn't say that's exactly correct, because right now, historically, the lottery oversight has always been economic development and tourism. So, you know, and it would be the will of the General Assembly if they want to change it to the regulated industries of both houses. It makes no difference to me as long as there's oversight to these operations.
Okay. You know, when we first had marijuana, I was dead set against it. Once it became, and we passed it, and we had a bill in the House, and it was going to be medical life, supported trying to, you know, make sure that we had good guidelines around it. And last year, a bill came to my committee, and something happened that had never happened to me before. And I would like to know if it isn't true that the person who came to testify is one of the people that would get one of these licenses, or maybe owns parts of maybe 3 of them. And what happened in that committee, and somebody that's a big supporter, not a former member, was there with me and listened to this and was offended by it also, and so was my committee, because we were threatened, literally screamed at and threatened over and over again if we did not do what this gentleman said. Apparently he does have a son that needed medication, but in the end he did not let us know that he owned or would own 3 of the possible ones that you're in litigation for it. And it would seem to me that in trying to keep this above board and have, you know, really the best people run the companies that produce this marijuana to be above board and honorable people, that having somebody like that threatens everybody on our commitment and told us told us he would come after us and find us, is not the kind of person that we would want, you know, producing marijuana and selling medical marijuana in our state. And I just would like to know if that person would be getting and involved in some of the ones that you're expecting to span with in these ones.
My distinguished colleague, I don't know. I know the gentleman you're talking about. He has been very emotional. He's like a lot of the a lot of the family members that have children that are in need. I know the guy you're talking about is regretful and was disrespectful to your committee, but I don't know what his investments are. I don't.
I think he owns 3 of them.
Chairwoman, if we'll,
but that would also be up to
suspend it. Chairwoman, I just remind you to allow Chairman Powell to finish before interrupting. The members are always reminded to respect other members with the decorum that becomes this House and especially this committee. Chairman Powell, you may proceed.
Yeah. But as I was saying, I don't know what his investments are. I know that he was like so many of the parents of these children that had to go to out of the state to basically smuggle cannabis into the state. I know that it was a highly emotional issue to these family members. I did not attend that committee meeting since it wasn't my committee, and that bill was being heard in Chair Lady Cooper's committee. I did hear of the incident that she talks about, but I cannot answer whatever his investments are.
Thank you.
Number 16, who's that over there? Vice Chairman Reeves.
Chairman Powell, you gave an estimate earlier about the time frame of the litigation. You said spring or summer of this year, possibly.
That's what the attorney.
And that was at the Court of Appeals level, right?
It's at the Court of Appeals level, as I
there's
understand.
a big win or a big loss at the Court of Appeals level, it's likely that the winner or loser is going to petition for cert to go to the Georgia Supreme Court, right?
That's my understanding.
And that's going to take another 3 to 6 months to hear back from the Supreme Court on whether they're going to take it. And then once they take it, that could be another 6 months or a year, right?
It would be drug out indefinitely. Yes.
And I'm looking at the bill, but refresh, or for the benefit of the new folks, what was the original time frame? When was it enacted, and when did you foresee?
This bill was enacted, the legislation was enacted in 19. So it's 4 years now. And now this is still hanging on and could keep hanging on unless we fix this. Thank you.
Representative Fleming.
Thank you, Mr. Chairman. I have learned something here today that this is number 16.
Duly noted.
And I
If y'all
took,
just
I
stay
took,
there
I
the
took
whole
my
time.
pen and I wrote it on there, 16,
Good.
so I can remember and answer your question correctly.
Thank you.
Chairman Powell, thank you, and I appreciate you talking with me previously about the bill, and I'm going to ask the question now that I asked you earlier that we talked about being difficult to answer, but I throw it out there so as we get testimony and move ahead, it can try to be answered for us. And the question is this: based upon the idea that whenever the government takes an action, such as creating this licensing procedure as we did, you sometimes create rights for the parties that are involved. By analogy, when a government hires an employee, we create what we call a property right that the employee has in their employment, and the law requires you go through certain hearings and procedures before you can dismiss them from their employment, for example. Or if a person owns a property and it's a zoning issue at hand, they have vested rights in that property, and when the government takes some action, they gather more rights and expectations of what they can or cannot do with their property. And if the government goes back later after that and changes it in an improper fashion, instead of creating less litigation and moving something along faster, sometimes you cause more. And that's really my question. I certainly understand the desire to effectuate a remedy and move this along faster, but I want to make sure that the remedy that we attempt does not complicate the situation further, because we have pressed improperly upon someone's vested or encumbered rights by the previous license process. So I throw that out there because I know you and I have discussed it before, in hopes that as we move through this, that we seek an answer to that.
Well, as we all know, I'm not a learned attorney, but I have been around and I have picked up a lot because I've learned from a lot of attorneys, including yourself. I understand that it is the General Assembly can change with every time we pass a law. It changes conditions and things such as a licensure on this. By changing, of course, the bill itself, it's basically a way of getting us, moving us forward, to right or wrong, to get out of the court systems. And trust me, I'm one of those people that believes that anything that you can do that you don't wind up in court, you have done something good, because that drags it out. Now, I'm not sure that there's any encumbered wrongs by doing this. Right now, you have two of the licensees, the two Class 1s, they're building out. They bought the property, they've been building, they're growing their marijuana right now. So maybe one of the problems would be they're going to be in operation, but nobody else is. They already had a jump start. But by virtue of this is moving forward. And I'm sure there are some more learned attorneys here that would like to address the part about the encumbrance.
Thank you.
Thank you.
Well, I got another question from another learned attorney over there. Chairman Leverett.
Thank you, Mr. Chairman. When you said learned attorney, I was spinning around to see who you were calling on. I appreciate so much that compliment. Chairman Powell, as I understand this bill, you are not proposing to withdraw a license from anyone who has been awarded a license. Is that correct?
That is correct.
You are proposing instead to award licenses to all of the people or the entities that were awarded licenses through the bidding procedure.
That is correct.
And in addition to that, you are also proposing to issue additional licenses by statute, effectively.
To those that have been involved in the legitimate protest. And have filed litigation.
So was there anything, to your knowledge, in the original legislation that would have provided some sort of guarantee to those who would be issued a license from the initial process that no licenses would ever be issued under any circumstances?
None that I know of.
Okay. Thank you.
I think the only guarantee at the time of the passage was that the application process would be issued, and then it would be a straight up and down operation based on the best companies. And I have some doubts, but you know, I remember it still sticks in my mind that one of the things that we had talked about was that these would be Georgia-based companies. Well, quite frankly, I don't know if any of them are. There may be a few of them, but you know, the biggest one is growing right now is based out of Florida. You know, and I see some of the rules and regs that are posted that have been posted that have been since rescinded by the Cannabis Commission just as early as last week, after over 3 years of them working. They issued a set of rules and regs that they were going to do. Now, quite frankly, the only rule and reg that I saw posted that I had a problem with was I think that they were going to charge $40,000 for a laboratory license, which was outrageous in my mind, to do a $40,000 fee for a license to evaluate this type of medical oil. And when we looked, and the attorneys and our committee attorneys looked, and they said there were so many Scribner's errors in their rules and regs that they said that needs to be cleaned up because of the legalities of the interpretation. And of course, I had called and made a recommendation. There was no discussion because they don't discuss things. And I had made a recommendation that if they were going to have the hearing online, have the hearing and postpone a vote until they could clean up the Scribner's errors. And I got a call back, well, we passed it. Well, then the next day I get a call from one of the senators who was on their cannabis, the single member that's on their cannabis committee. And he said that he got a call that morning that they had to rescind their rule and reg process because they didn't run public notice. Now that's just, I mean, I don't mean to make it look bad, but that's not how this state should do business. It's just another setback.
Agree. One follow-up, Mr. Chairman. So, to Representative Fleming's point, that was a concern of mine as well, and I'm certainly no government contracting lawyer, not the sort of the missteps regulatorily, but just sort of the legal issue involved in issuing additional licenses when we initially were not intending to do so. But my general understanding is the issuance of a license does not give any assurance, unless it's specifically stated somewhere, that no other licenses will ever be issued. So
Correct.
it would seem to me that there, again, while this is not a legal opinion, that there is it would be unlikely that the companies who were issued licenses could complain about the additional issuance of licenses to other people, as long as they are awarded licenses, which I think your bill proposes to do.
That's exactly right.
Thank you, Mr. Chairman.
Okay. All right. We have some folks signed up to speak to the bill. Mr. Chairman, if you just scoot over there for a second. I have Miss Kristen Goodman. If you'll just come up and tell us who you're with, and welcome.
Thank you. I usually do not have a need for a microphone, so I will try, as many lawyers don't, to speak quietly since I do have the mic in front of me. So my name is Kristen Goodman. I, along with my colleagues Jake Evans and Les Schneider, who's in the room with me, represent most of the 8 protesting companies. And what I would like to talk to you about is a little bit of the background about how we got here, why we believe that Chairman Powell's bill is the absolute best remedy to move everybody forward in this state, including those who already have licenses and the patients who are waiting on this very effective medication. I'll be happy to answer any questions about the litigation, about the legal process, where we've been, where we're going. Chairman Powell actually did a very fine job as a quasi-lawyer of trying to explain that, but I can talk a little bit more about the timing, where we are procedurally, and why we believe that this is the best opportunity for this committee, for the General Assembly, for those waiting on this medication, and those who have been so deeply involved in this process. This is the best solution. While we were listening to the opening prayer, there were 2 words that caught me in that prayer, and those were right reasons. Those 2 words really can carry the theme of everything I have to say to you today, both where we've been and where we're going. I have congratulated and I commend the persistence of Chairman Powell, of everyone who has worked on this process, of the other members who have signed on to Chairman's bill, to the legislators who tried desperately last session to solve this problem. When this bill was passed, first, as Chairman Powell said, 7 years ago, and then again 3 years ago, the effort to bring this medication to people who needed it, there was no question that this was for the right reason. There was also a commitment made by the body, by the people who sought to apply for these licenses, by the physicians who stood by the medicine, by the science that proved to people who were concerned about recreational use and abuse and black markets and things like that, that this was worth the effort. The compassion and the courage that this body took and displayed in passing this legislation to begin with and allowing this to come to Georgia citizens cannot be understated. And right now, everyone who had that courage and compassion is waiting. This body, when it awarded or when it undertook this legislation, made a commitment. It made a commitment to the integrity of this procurement process, which could not be more important. We're talking about a federally illegal substance. If we are going to get procurement right, this is the time to do it. We have seen other states train wrecks in the process. We set out to make this an apolitical process, to make sure it was done right. This body also committed itself to the groups of Georgians who had a stake in the bill, the patients who are waiting, the veterans with phantom pain, the cancer patients, the children with epilepsy, the desperate parents who I believe the chairwoman had the misfortune of being on the end of. There have been some angry and desperate parents, and I can speak to the issue that she raised as I get on. But the second group of people that this body sought to benefit were Georgia small businesses. This legislation was to be by Georgians for Georgians. The understanding being that Georgians would do this for the right reasons. What does by Georgians for Georgians mean? It means small businesses dedicated to their communities, to empowering economically disadvantaged communities, to empowering minority business owners, not just the minorities that have several advanced degrees who happen to have been an executive in one of the multi-state operators that applied for another license in Georgia, but the minority business owners who have given their lives to improving the communities in the state of Georgia. Those people were left behind in this process. Now, what went wrong? Well, quite a bit went wrong. The first thing that went wrong was that, unfortunately, the body that was trusted by the General Assembly to apply procurement rules in a consistent, appropriate, fair, neutral manner with transparency, without conflicts of interest, without political favors, without predetermined outcomes, dropped the ball. And that's an understatement. Wrecked the train might be a better explanation of what happened here. Now, we can talk about what went wrong, but how can we prove it? Well, we can't, because, as Chairman Powell said, the cloak of secrecy that surrounded this process has proved to be impenetrable. We have been denied documents, we have been denied explanations, and I will give you an example. 2 of the people holding licenses right now redacted all but less than 15 pages of 2,000 pages of applications. 2,000 pages. We don't know what happened. We do know that certain winners placed their facilities within the limits that were drawn for a church or school. They got a license anyway. We know that certain donations were made to the benefactors of certain committee members. They got a license anyway. But we have been unable to access the information to show how truly flawed this process was. Other examples, some of these companies were not even Georgia companies at the time they were submitting their applications. Many of these companies, and I know because I worked with people in this space prior to representing one of the applicants, they told me exactly what they do. These companies, the multi-state operators, want to expand their national footprint. The next thing they're going to do is push for recreational use. The next thing they're going to do is make sure that they have a good national footprint in place for when this medication, for when this substance is decriminalized at a federal level. So, where will small Georgia businesses be then? I will submit to you they will be nowhere because they were left out of this process. We have stood as a group of protesters, not just for our owners. I will tell you that I believe very strongly, and I believe the reason that the ones who currently hold the licenses are pushing so hard is not because they truly believe that the market would be flooded, and I can speak to that a little bit, but because they have a monopoly. And everybody in this room, and certainly everybody who's an attorney has studied this, and everybody is probably a business person as well. And I can give you an example. Minnesota, for example, had a very few licenses when they first started with medical cannabis. That was so inaccessible to the people in the far corners of that state and the people who could reach it. $2,000 a month. Now, I will tell you that the veteran or the person who's living on Medicaid or Medicare does not have $2,000 a month to pay a multi-state operator who's accountable to their investors and their shareholders. But the Georgia small businesses who were left out of this process, they're located in every corner of the state. The people who were in the licenses that were awarded, for example, are centralized in the Metro Atlanta, Macon, and Augusta sort of geography. And I'm from Atlanta, I live in Savannah, but I'm, have learned, even though I'm from Atlanta, that there are places outside of the city. But so we know now that took me a while, by the way. I have some clients who say they taught me more about Georgia geography than I ever learned in school. but the licenses that exist as these putative licensees, they're not serving the children who have excessive seizures in Northwest Georgia. They're not serving the cancer patient in Southwest Georgia because those people probably don't have the transportation to drive halfway across the state to access one of a few dispensaries. And you know what? The licensees have all the market they need right here in the densely populated center of the state. But these small entities, these small Georgia companies, my client is just, I have several clients now, but the original one I started with, they're people in the medical field. They have second mortgage remortgaged their house. They have emptied out their retirement to found this company to employ people who are true veteran business owners, minority business owners in McIntosh County, Georgia, where they can do some good. And that is what is motivating the protesters in this case. It is the right reasons. Don't think for a minute that anybody wants to spend more money on me. And I would love it if they did, because I've still got a kid in college. But they don't. They want to do the right thing for the right reasons. Now, when we started this process, when we started, as Chairman Powell said, the protest process, we followed the rules. Most of the protesters did follow the rules. We filed the administrative process. What we raised in those protests were lack of transparency, inconsistency, and an arbitrariness in the grading. They completely ignored the widely understood and accepted concepts and rules in the Georgia Procurement Manual about how applications are to be graded. They essentially interpreted the General Assembly's rules that, or I should say statement, that this particular procurement was different, as giving them a carte blanche to throw the baby out with the bathwater, that they could do whatever they wanted to do in this procurement, and they did. And as a result, we have ended up with a complete insult to the integrity of our procurement process, an insult to this legislative body that sought, for the right reasons, to do the right thing. They didn't do the right thing, and we have now ended up with 6 licenses in the hands of multi-state operators who have no interest in small Georgia businesses. And as I said before, when I was working with some long before it was even an issue in Georgia that an application could be made, they told me that what they do, they go find investors in a state where there's going to be licenses available. They get a couple of investors, they form a Georgia LLC or another state LLC, and they call themselves that state's company. They're not a Georgia business. They're not a Georgia small business. The 8 people I represent, or the 6 of the 8 that I and Mr. Snyder and Mr. Evans represent, these are people who are doing this for the right reasons and are exactly the kind of people that this body had in mind at the time that this license procurement process was started. Now, we have been criticized, and I'm certain that there will be further criticism, that we are somehow holding the process up. And I want to assure everybody in this room that that is absolutely not true, that we have done everything in our power to make sure that this process happens fairly, appropriately, and quickly. But licenses who give patients no access and who have no affordability, that's not access. We have not served the people in the state of Georgia if we allow this to stand exactly how it is. The result of what has happened, and if we allow this to stand with these 6 licenses, there are 2 things that are going to happen. The first thing is we allow these companies to move forward while patients are suffering and they reap benefits and monopolistic prices. And that is not what we need to do for the citizens in the state of Georgia. My clients, the people I know who I have spent hours with protesting this process, stand for the Georgians in the outside of the state. They stand for the minority business owners who were left out of this process. Everybody in this room knows that litigation results in delay. We don't like it any more than anybody else does. And we know that Chairman Powell's bill is a way to avoid this process. But we cannot, for the right reasons, allow this process to simply move forward and give up, because we know it was flawed. We know it was a simple train wreck. We need to make sure that this process we owe it to the citizens of the state of Georgia, the people who are waiting on this medication, and the businesses who committed themselves to go into business and provide access to these people at a reasonable price. We owe it to them to continue our fight, and we have every intention of continuing that fight. Now, I would like to explain very briefly where we are and why we're continuing this and what the potential outcome is. If Chairman Powell's legislation is not passed and the litigation goes as long and results in the outcome that we think it will, which is that ultimately we will be given access to what we believe exists that will prove what a flawed process this was, it will be thrown away and we'll have a do-over. Now, I frankly don't want anybody to have to wait another 3 years on this medication. It's not in anybody's best interest. But we can't excuse or justify what happened by the urgency of the outcome that is so desired right now, which is let's just get to the market, get to the market. We don't care about the quality. We don't care about access. We don't care about price. Just get to the market. And that's not going to serve anybody. And that's why we're here. Now, I can speak to the market question, and I think it's an important one. As Chairman Powell said, we have studied the population sizes of other medical use only states. And we believe that this state, when all conditions that should be on the registry, and the ulcerative colitis happens to be a very broad one and will expand the registry, I think, quite a bit, that there will not be any excess whatsoever. We believe in the market. We know, and my husband is an immunologist, he has studied the cannabinoid system extensively, and as I believe Chairman Powell said, there are different types of cannabis products that address different conditions. There's different efficacy based on growing techniques and different things. We believe people deserve the best market, the best product, and that is what a market is going to bring to them, is the best product at the best price and the most efficacious product for people who need it. The fact that the bill does also include the ability for a dispensary to receive product not just from the manufacturer they're connected with also allows that decentralization of product that will benefit these individuals. So our belief is that, to the contrary, the number of licenses, which is still quite a bit lower than license numbers in states that have similar medical markets, will actually be much more beneficial than letting a monopoly remain in place. I can also say that I don't believe, and I'm not out there shopping for it, but we have a very, very low THC cap on the medical cannabis in this state. It's not something that people are rolling out and smoking. That's just not what they're looking for. I don't think that they're going to be, I think there's probably enough on the market with where people buy it. I don't know, I don't have personal experience, but considering how low the THC is in this product, I don't think it's a significant concern. Can also speak to the question of will the winners sue. That would be maybe one of the most hypocritical things I've ever seen, but given that they are accusing the protesters of delay, but the more important point is they have nothing to sue about. There is no basis in any law, whether that's the one that's passed or the one that's existing, that would give anybody a right to sue somebody because their return on investment is lower than when they forked out the money to invest in the beginning. And I would say that those companies have plenty of shareholders and dividends to go around anyway. So I think if everyone is truly, like I said, in this for the right reasons, we will get this legislation passed, we will get these additional licenses, and the people who are waiting everywhere in the state and the businesses who are waiting and ready and willing, like our clients are ready to go, we will do the right thing, it will happen for the right reasons, and we will finally get the patients that you guys had the compassion and courage originally to do this for, we will get them what they're waiting on. Now, I can speak a minute for where we are in this judicial process and explain why it's going to actually go on, I think, quite a bit longer than unfortunately was assumed. After we completed the protest process, which was required, and keep in mind that we're not asking, again, for the people who have gotten licenses to lose those licenses. Now, we think that they didn't get their licenses under appropriate terms, but for purposes of moving forward and making sure the entire state has access and affordable access to this medication, then we believe we're ready to move forward. What we did was play by the rules. We did the application the correct way. We were Georgia businesses. We believed that the scoring process was flawed. We had substantial evidence of that. We participated in the administrative process. After that administrative process concludes, there is a right under Georgia law to get judicial review of an administrative decision. There are two potential mechanisms for judicial review. Because of the lack of a specific reference to the APA in the legislation, the Administrative Procedures Act, the winners have argued that our only option was to do what's called a 541, which is filing in Fulton County Superior Court for a review. If you want to stay the licenses, you have to seek an injunction, which any lawyer in the room knows is an extremely difficult task. The other option, which we believe that because of the way the legislation was structured, its reference to the Georgia Procurement Manual, that the law did come over the Administrative Procedures Act originally, we pursued the remedy for judicial review, which was set forth in the Administrative Procedures Act, which is called, for short form, 501319. 501319 can be filed in any county in which the petitioner does business. That means that every protester, every losing company who sought to protest, and not all did, but there were close to 70 applications. We had 20 protesters maybe out of the gate, and some of those were protesting both a Class 1 and a Class 2. To this day, there are only 8 left. Those 8 pursued judicial action under 501319, which was in their home county, where 2 things occurred. One, a judge who is familiar with the county so that he could better evaluate descriptions of whether a Tier 1 and a Tier 2 or a Tier 3 county, what was the appropriate demographic information to use for your labor statistics, where someone who actually had some knowledge and interest in that would be in a better position to evaluate whether the evaluator who scored our application got it right or whether it was ultimately arbitrary. So the protesters elected to file under 501319 in their home counties. Of course, the commission, the state, the protesters did not like that whatsoever. They wanted to be in Fulton County, where and under the 501319 rule, you were entitled to a stay for good cause, which meant that the stay could be issued prohibiting the GMCC from awarding the licenses until we could be heard, a statutory right to be heard, a statutory right to get judicial review. We filed those cases. We were inundated with briefing by the winners trying to get us dismissed from those courts, claiming we should be in Fulton County Court under the 541 process, where we would not have been able to get a stay, where they would have, as they did, try to expedite a hearing and get a shutdown immediately, okay? So we all filed 501319s. There are a couple still pending. Most were dismissed basically performatively, just right out of the gate, with an argument that 501319 didn't apply because we were not specifically under the APA. As a protective measure, we filed 541s also. So at the same time, we had 2 cases pending, both of which would have afforded judicial review, but on very different terms. When we got dismissed from the 501319s, we still had our 541s, which has, by the way, 541 has been repealed. It is widely known to be a landmine of a bill, and that many, and somebody, yay, okay, thank you. Read 541 if you really want to, like, it's like a Rubik's Cube. It's bad. So 541 has been repealed effective July 1st of this year. So they were trying to push us into a statute that was well known to be a landmine procedurally, so that we would somehow mess up, which happened several times, and that we would then, they could say, oh, we pushed you into 541, but now we get to dismiss you from 541 too, because they don't want this heard, okay? They don't want it heard. So we appealed to the Georgia Court of Appeals dismissal of the 501319. This is law review, law exam stuff. We had to file a discretionary petition to ask the Georgia Court of Appeals to take the appeal. We didn't get an automatic right to appeal the 501319. We submitted that, and the Georgia Court of Appeals has accepted it. And the question was supposed to direct us on whether 501319 or 541 was the proper method for judicial review. That case has been accepted by the Court of Appeals. It is sitting in the Court of Appeals. We are finally docketed. Our briefs are due in 2 weeks. We'll be tentatively scheduled for oral argument on May 3rd. We may get a decision. There's a 6-month rule in the Court of Appeals. We will get a decision by the end of the year. But understand that all that tells us is whether we're supposed to be getting judicial review under 501319 or 541. We haven't even done judicial review yet. That's just telling us which court we belong in. Now, the winners have already gone into the 541 court and asked for an expedited hearing, trying to circumvent the Georgia Court of Appeals clear statement that we don't know which forum we're supposed to be in. This is just part of the mess of the statute. So I hate to bring that up, but it is the reality that the original statute didn't make it clear. So we've got to wait on the Court of Appeals, then we got to wait on a judicial decision. If we lose in the Court of Appeals, as noted, we might be up in the Georgia Supreme Court. This is not going to go away. It's not going to go away for probably 18 months to 2 years. And the reason is not for delay, it's not for money, it's for the right reason. So we are here asking you guys to sign on to Chairman Powell's bill to allow everyone to move forward and do the right thing for the citizens of the state of Georgia.
Thank you, Ms. Goodman. Members of the committee have some questions. Thank you for the, thank you, thank you, Ms. Goodman, for the thorough job on appellate procedure. Thank God I'm a trial lawyer.
I love appeals. I clerked on the 11th Circuit and was the appellate lawyer for the Southern District of Georgia.
It shows.
It is my jam, yep.
Representative Fleming.
Thank you, Counselor. 2 questions.
Sure.
The first one is the one I attempted to ask Chairman Powell. Can you assure us that our passing this bill is going to eliminate litigation and move the process forward and not simply possibly create more litigation by the 6, as you refer to them, winners from the start?
I can assure you that I can assure you of 2 things. I can assure you.
Miss Goodman,
Yes.
if you could just pull that microphone a little closer so we can pick you up. Thank you.
I can assure you of 2 things. One is that the licenses that are in this bill that are proposed to be given to those who have stayed in this process this long, no one else who has applied for a license or participated in any sort of post-award protest is eligible to sue or to seek a license. So as far as from our perspective, from those who are not currently holders of a license, the litigation we are currently involved in would be moot. It would be dismissed. Now, if the Judiciary Committee wanted to include a term in that legislation that made that abundantly clear, as if there was a contingency or something like that, we would be fine with that. But from our perspective, if the legislation were to be passed, the litigation is moot. So we have no reason to continue litigating and would rather our clients spend the money building their facilities and getting this product to market. As for the 6 who hold licenses, I am unaware, and I've read this legislation upside down and sideways, of any basis on which they could possibly file a lawsuit. There is no entitlement. There is no right to exclusivity under these laws. So to my knowledge, the answer is it would end.
Second question, and I'll ask it. Second question, if I may, and I'll ask it, and you can tell me why the premise is wrong or the result was not what I say it is. It's my understanding that the governor ordered the Office of the State Administrative Hearing Judges to review the whole process that we're discussing here and find out if it was flawed or there were any problems. And their result was no, there was not flawed and there was not any problems.
So what happened was we were originally in front of Director Turnage, who, as the original legislation read, was to sit not only as the one who headed the committee that awarded the licenses, but also was to be the judge of whether they did it right, which was a clear conflict of interest. They asked OSA to sit in the shoes of the commission to review the commission's actions. The one judge, one ALJ, was given the task, and I think it was a large task, of holding hearings on every single one of these protests. Now, keeping in mind the thousands and thousands and thousands of pages that were involved in this application. And those protests that we did have hearings, what ended up happening was the thousands of pages of applications were still denied to us until the very last minute, like literally right before the hearing. They were still heavily redacted. We were not able to save, search, or print any of those documents. We were unable to allow the experts, some of the sections, for example, this is like asking me the technical details of building an airplane engine. I could not tell you, you don't want me looking at that. we were unable to consult with our experts to even show that the application, the evaluators got it wrong. So basically there was a performative dismissal of every single protest. So we contend that that protest process, that evaluation of the determination of the protest itself was also flawed. She also made some decisions about waiver that we believe were absolutely incorrect. So as a matter of law, we believe the decisions were incorrect. Sure. That's what we're appealing, by the way.
Who's number 5 over there? Representative Miller.
Thank you, Mr. Chairman. Thank you, Ms. Goodman, for your presentation today. I just had a couple of follow-up questions based on what you testified to. You indicated that part of the rationale for the process was to make sure that this was for Georgians by Georgians, and that small businesses, minority-owned businesses were included in the process and had an opportunity to compete for these licenses. The minority business owners who I guess you have described as being left out of this process, will this bill remedy the process for them?
Oh, absolutely. Because many of the companies that we are representing right now had and do have substantive vendors, owners, shareholders, directors, board members, and officers who are Georgia-based, lifelong Georgia business people who are minority business owners. I mean, I can give you an example. Kofi Smith is one of the vendors and Trox Austell, who's also a client of mine, who are long-time minority business owners, very devoted to the state of Georgia, are board members of one of these clients. So those are not just figureheads. They're people who are on the ground working and participating in making the state a better economy for minority business owners.
Okay, so they would be part owners of the businesses that are.
There are many minority business owners in the companies that we are representing as protesters.
Okay. My second question is, will this bill retroactively require the type of disclosure that you said you've been denied? So in other words, if this law changes, will you be able to go back and get all the things that you say you have not been able to get?
We would be. The hope is that we wouldn't need them, because at that point, the issue of the litigation would be moot. But the legislation as it's drafted, and it's my understanding, and Les can speak better to it than I can, but that the Open Records Act will now apply. They have been claiming all along that they did not need to comply with that, and that is being brought into this legislation so that materials that were previously redacted, that we were unable to have access to. And if we go through discovery in one of the lawsuits, we do anticipate, based on the amendment, based on the discovery rules, that we will have access to those materials.
I'm sorry, I had one more question, Mr. Chair. May I? I guess just to be clear, some of the allegations that were floated sound to me like there might be some criminal activity going on, or there was some criminal perhaps intent, or when you talked about people getting money in exchange for giving licenses, I mean, I may have misheard you, but that's the gist of what I thought you were saying.
I think I can't attest. I'm definitely not a criminal lawyer, and I would not want to impugn somebody in that to such a degree. But I would say that it was a violation. What we believe occurred was a violation of the conflict of interest rules that exist in the Georgia Procurement Manual. So some of the rules that should apply to decision makers in the procurement process were ignored, and that's the problem. I wouldn't say in any way that there was a direct exchange of money for a license. I will just say that because it was not a blind process, the evaluators knew well that when certain donations were made to a particular school or cause that they believed in, but that donation could not be used unless that company that donated got a license,
I understand.
You might give them a really nice score.
Thank you.
All right. No more questions. Oh, wait. Somebody has a question. Let me guess.
Two quick
Which Court of Appeals panel has it, and is it just one
Vice
case?
Chairman
We
Reeves
don't know
is
yet.
recognized.
We were just sent the docketing information about a week ago.
And if that 3-panel splits, would it then go to the whole court, which would add on more time?
Possibly,
En
if
banc.
one of the judges asked for it to be heard by en banc, it's usually how it happens.
And how much longer would that prolong the process?
Probably another 6 months.
All right. Thank you very much.
Thank you so much for your time and patience. I really appreciate it.
Next, we have Les Snyder. Les, a lot of us know you. Just introduce yourself, who you represent. It's good to see you. You can be a hero this evening or otherwise.
Mr. Chairman, might I remind my dear friend that time is of the essence?
My name is Les Schneider. I'm with Wimberley and Lawson, and obviously I know a number of you. So I will be brief. As to Representative Fleming's point, I have seen, as you all remember, the fight that you all had over limos and taxis and Ubers and everything else. And the taxi people who had medallions went all the way up to the Georgia Supreme Court to say, God, you ruined our business. We had our license, and we need restitution. And the court said, you get nothing, because the legislature can sit and always add on licenses and other ways to do industries. Representative Silcox, I understand the Bain study. I just know that you're a realist and I'm a realist, and if West Virginia with 1.8 million people can have 10 cultivators, and Georgia has 10 million people and they have only 6, I would question this. And if you look at Pennsylvania, 12 million people, 25 cultivators. So clearly I don't think the compromise here is being done. Representative Cooper and her experience was awful. Obviously, I sometimes do this for a living. Sometimes I do silly things like do things pro bono. But at the end of the day, there is a high level of emotion, there's a high level of disrespect that has occurred during this whole process. But the biggest issue we have here now, and I made the argument in front of the hearing officer and was chided by the other side because, gee, you made an argument to a legislature, not to a hearing officer. But at the end of the day, you all can't sit here and tell me there's not a lot of broken glass over what has occurred. Now, you're either going to take the commitment to sweep up the broken glass and help fix this, or we're going to have a situation where maybe reputations do get tarnished, maybe bad things will come out about what certain people did. But what are you all here for? We're here to move the program forward. And not only are there people that want relief, but more importantly, do we really want more discovery on how badly the situation was handled? I mean, Representative Powell has come before you with transparency, a fix, and, you all can criticize whether it's the perfect fix, but after being a lawyer for so many years and being married, you understand 2 things in life, that sometimes a good relationship in marriage or in business or even at the legislature is sometimes the best thing to do is have grumpy compromises and get this thing on the right road. Now, there is a body over here who Representative Powell sometimes speaks nicely about and other times not so nicely about. But we all know the Senate is going to have input on this thing, and there may be decisions made about whether there should be a cannabis commission in the future, whether somebody else should do this. Let's pass this bill today, and let's start the process. And let's not be so cautious or so worried about somebody's business interest that we're forgetting about the folks who need the medicine, how we handle the dispensaries, and let's move this forward. Representative Powell is not saying he's the repository of all good ideas, but at least he's put down 6 or 7 ideas to make the process better. And I would hope that you all could give him the impetus to begin to continue to work on this with the folks over in the Senate, in the governor's office, or anybody else who really gives a damn about what we want to do. Increased competition is not going to drive this industry into the ground. It hasn't in any of these other states. There is no inherent license right that says, I'm going to have this quasi-monopoly for the rest of my life. I mean, you all are people of pretty good faith. I mean, my experience with you is overall you want to get to the right answer. This bill is the start to the right answer. And I think if you can move it forward, it's going to bring other people to the table to make it even stronger. But if you don't move it, then there's going to be a game around here that I'm well familiar with, which is let's eat up the time so we get nothing done, or maybe we do something stupid in the last 24 hours of the 40-day session. So this is a chance to really start moving everything forward. And the hour's late, so I'm not going to belabor the point, although we all know the best line around here is not to belabor the point, but so I will be quiet. I'll be happy to answer questions.
Any questions from members of the committee?
Wow.
Les?
Yes.
Oh, we have one. My colleague from Alberton, Georgia, Chairman Leverett.
Mr. Chairman, I just wanted to say I find it extremely disillusioning to find that Chairman Powell is not the source of all good ideas, and I need a little time to be alone if that's the case.
Duly noted.
I measure everything in my life from things that happened before this moment and things that happened.
All right. Any other questions? Les, I have one.
Sure.
As far as the way this bill is structured.
Yes, sir.
Intent being the great intent that it is from testimony here today. My question is this, that those who are protesting,
yes,
if they were to withdraw from their current litigation, all of those who are protesting, just because they withdraw their current pending litigation they have,
right,
that doesn't guarantee that they will all receive licenses as this bill is intended to be constructed, or is constructed.
Under this bill, and I believe the wording is in section 6, which outlines that, and let me, okay, you can read the whole section 6, but if you start on line 149, a person that filed a post-award protest which is on appeal who had applied for both a Class 1 and a Class 2 production license, such notice or shall choose which class of license they want to receive. A person dedicated for 2, 1 and 2 can do, but they can't do both. The aggregate shall never exceed 8. What we're doing here is setting forth anybody who has exercised that right of appeal, and Ms. Goodman did a very clear job on it, either under 501319, 541, or any combination thereof. If they have done that, they are of the 8 that would receive the additional license. Now, they may choose a 1 or a 2 if they have applied for both. If they've only applied for a 2, they're only going to get a 2. If they've only applied for 1, they're only going to get a Class 1. So what we're doing is taking the people who have legal standing now, and they would get their license, as opposed to what happened in Florida, where they had an issue on licenses there, and I think there was an issue of minority participation and a number of other issues, and it took years, and the judge finally gave everybody a license, in addition to the people that really had done it. So under this, all of those 8 companies would all receive a license, in addition to the 6 that were done initially. And right now, of course, the 4 Class 2s are under a stay, but they would receive 2, it would be given out, and that would be the end of it. This is a compromise, and this moves us forward on the issue.
Thank you, Les.
Now you may. I'm sorry,
Yeah.
and I don't
Go
want to
ahead.
belabor. I don't want to belabor the point, but there may be a need down the road to make sure there's a sentence in here that makes it very clear that if your attitude is, look, we do want closure, we want to move forward, but we want further assurance that all the litigation is going to go away, then I would certainly say that Representative Powell should talk to legal counsel and make sure on any ultimate bill that gets passed in the entire General Assembly that the assurance that the litigation goes away is embedded in the bill.
Les, I'm going to belabor the point myself.
Go right ahead.
So, in understanding what transpired in this whole process, and I was privy to some conversations as a young baby legislator, and now I've got my tricycle that I can ride on now. I would ask this question. With your comments earlier and about how you've seen litigation such as this go forward before, and I think it was Aid when the medallion thing was going on.
Mhm.
So I remember that fairly succinctly. My question would be, this bill and the fix that it proposes to do is basically because the process was so flawed that when the courts really get into this and review the whole process and the standards that were applied or the lack thereof, as the contention of the plaintiffs in those cases would make the argument, this is basically to fix the process or cover the commission's mistake by making things right. Is that what I understand? Just to put it very succinctly.
That's right. I mean, we all make errors, and this is to sweep up the broken glass to be able to move on, as opposed to start from square one again and bring up all the problems. I mean, yes, it's a grumpy compromise, but it's a compromise that moves the system forward. Now, it does have, because of the APA, and it does have because of the oversight, that in the future, if you all decide you want to add more licenses or expand what the existing licensors can do, this gives you the opportunity to make sure that those issues will be addressed in the future for any other license. But yes, if you're asking me, does this sweep up the broken glass? Yeah, it's exactly what it does.
Okay, thanks, Les. Any other questions? All right, that's all the questions we have. Now we're in the discussion period for this bill. Representative Byrd, would you wish to be recognized? Anyone wish to speak to the bill? Anyone? Number 2, is that Chairwoman Cooper?
Okay, I do want to clarify one part about some testimony. And I've been here since the very beginning. The first hearing on a bill on marijuana was in my committee, where it got pretty heated, and the side that wanted the marijuana went first and became so not combative, not as bad as it was on the other thing, but were yelling and carrying on so bad the other side could not present, and we had to just, just cut off all discussion of the bill. So it's been very contagious from the very beginning. But the one thing I want to clarify, our state has one of the highest, we are not a low TCH state on medical marijuana, just so you will know. It misnumbered. When the bill started out and it moved, it was 0.5%. 0.5. And in the process, it got up to 5. So we have one of the highest TCH points of medical marijuana in any of the states that have medical marijuana. In the 60s and all, not something I tried, I was in nursing school, wouldn't have been a good idea. but people were getting high on 3 and 4%. So it is high. Now technically they can produce it, I'm understood, to where the TCH goes up to 20, sometimes with all their manipulation of the molecular components of it. But our state's bill is very misleading because it is not a low TCH bill. Just to clarify the record.
Somebody hit the button again over there. Okay. Just want to make sure. I had somebody over here. Well, anybody else? What's the pleasure of the committee? Motion second. All in favor of the passage of the bill, say aye. Aye. All those opposed, no.
No.
Ayes have it. We are adjourned.
Thank you very much.
Ladies and gentlemen.